Hello and welcome back to Strict Scrutiny, your podcast about the Supreme Court and the legal culture that surrounds it. We're your hosts. I'm Kate Shaw.
I'm Leah Littman.
And I'm Melissa Murray. And even though the temperatures are beginning to cool, and the students have returned to school, and the pumpkin spice is beginning to return to the land where it belongs, the Supreme Court hasn't yet started hearing oral arguments, and they won't until the first Monday in October. And that means we've got another few weeks of our summer schedule, which means we will start off this episode with a news segment, and then we will bring you a conversation with a terrific guest, Yale Law professor Justin Driver, who will be speaking with us about his new book, The Fall of Affirmative Action.
But first up, news. And we've been off for 2 weeks, which means we have a lot to cover. And since there is so much, we're going to basically group our discussion into a couple of themes. First,
Dumb and Dumber.
No, the first one's actually quite good. They're both good, but they're responding to the bad. The lower courts are continuing to hand down important rulings against the administration. That's good. And related, lower courts are responding increasingly explicitly, not just to POTUS, but also to SCOTUS, including by expressing real frustration from what we are seeing or not seeing from on high.
We'll then talk about some of our favorite justices' recent public appearances. JK, we do have to cover the recent public remarks by both Brett and Amy, though. But let's start with the good, the pumpkin spice, if you will, which is the lower courts handing down rulings against the administration. Because it's been another banner few weeks for the whole law thing, it means it hasn't been a great time for the administration in the courts.
And let's start with an important opinion from Judge Charles Breyer in the Northern District of California in the case involving the deployment of the National Guard in Los Angeles. So that's what the case grows out of, Trump's decision to send the National Guard to L.A. back in early June to respond to protests over the administration's wildly aggressive immigration enforcement actions in that city. Listeners may recall that we were actually on stage in New York during a live show when Breyer initially ruled against the administration, granting a temporary restraining order. So let's roll that tape.
We might have to interrupt the game.
Oh, no.
Judge Breyer decided he wanted to participate in said podcast.
Okay.
We have a cameo from Judge Breyer.
We have a cameo from Judge Breyer, who has ruled that President Trump's use of the National Guard in LA was indeed unlawful.
Wow.
Okay. Kate, Judge Breyer knows how scared you are of pop culture, and he
This
came
timing was for me
to
only.
your rescue.
Okay. I don't mean to be the fly in the punch bowl, but this is clearly going up on appeal, and I think Donald Trump right now is thinking, you'll be back like before. It's my moment.
As Leah subsequently recounted, Judge Breyer found that the government likely violated the federal statute that concerns the prospect of federalizing the National Guard, as well as violated the 10th Amendment. At that point, the court declined to rule on an argument that the government had also violated a different statute, the Posse Comitatus Act, that prohibits the military from engaging in domestic law enforcement.
And as Melissa predicted, the Ninth Circuit later stayed that temporary restraining order, essentially finding that given an appropriately deferential standard of review, which requires only a colorable basis and good faith, it was likely that the president had not violated the relevant statute about federalizing the National Guard when, quote, the president is unable with the regular forces to execute the laws of the United States, end quote.
Okay. Well, wrong at the Ninth Circuit, but okay, that's where we were. Judge Breyer then in the district court proceeded to actually hold a trial on the claims that this deployment violated the Posse Comitatus Act. Remember, the statute he hadn't ruled on initially. And a key part of the trial was devoted to this question of whether military officers were performing ordinary law enforcement functions. And last week, in a scathing opinion, Judge Breyer found that the Posse Comitatus Act did apply, that no statutory or constitutional exception to Posse Comitatus applied, and that the kinds of actions these federalized forces engaged in were clearly law enforcement in violation of Posse Comitatus. The court relied on evidence and testimony at trial that established that the government, quote, used armed soldiers, whose identity was often obscured by protective armor, and military vehicles to set up protective perimeters and traffic blockades, engage in crowd control, and otherwise demonstrate a military presence in and around Los Angeles.
The court described this effort and the president's announced plans to send the military into other cities as designed to create what he called, quote, a national police force with the president as its chief. Pretty chilling stuff, all told.
So just to drive home how chilling the government's arguments were, Judge Breyer identified some of the things the federal government might be able to do under the kind of authority it is claiming, in particular if the standard is as deferential as the Ninth Circuit seemed to suggest it was. So he suggested that the government could say under enforcement of tax laws, the fact that some people underpay their taxes would allow him to deploy the guard. So too, the fact that businesses continue to engage in pollution in violation of the Clean Water Act, or the fact that people show up to hospitals with symptoms of drug use, and are violating federal drug laws. And he could, and we're going to quote this one here, by, quote, relying upon anecdotes from state election officials that voting machines are glitching or that fraud exists, could claim that he is unable to execute the election laws, end quote, and federalize and deploy the National Guard on that basis.
Just, purely hypothetically, right? I mean, it was very clearly a quite deliberate selection because this specter, with elections looming, not just like the midterm elections, but the election on the California redistricting ballot initiative and the prospect of federalized troops in the streets, that's a terrifying potential combination, and Breyer wants everybody to be clear-eyed about its possibility. So the court enjoined the defendants from violating the Posse Comitatus Act, essentially ruling that they could not engage in law enforcement activities, although they could, and a few hundred of them actually do, remain in California and in Los Angeles. So next stop, just as Melissa predicted with the temporary restraining order, next stop with respect to this opinion is clearly the Ninth Circuit. And I think it's a really good opinion, and I do think it's a very scary case because it could give SCOTUS, if it goes up, the chance to ratify some of the president's, I think, most chilling assertions of authority. And there's much more to say about this case, but we have too much more to cover to linger. So onward.
Next up, if you need more evidence that this has been a very terrible, very awful, very bad week for the Trump administration and the federal courts, guess what? I've got more news for you. Donald Trump lost a very important case in, wait for it, the Fifth Circuit. Yes, that's right. The crazy one. He lost in the crazy circuit. The case, which was back before the Fifth Circuit after an encounter with the SCOTUS shadow docket, marked the first time that a court of appeals had ruled on the merits of the Trump administration's efforts to use the 18th century Alien Enemies Act to justify expelling members or alleged members of the Venezuelan gang Tren de Aragua. The court found that on the record presented, the administration did not satisfy the requirements of the Alien Enemies Act, which gives the president a lot of authority, but only if there has been, quote, an invasion or a predatory incursion. The Fifth Circuit concluded that this standard was not satisfied here. There were 3 judges on the panel. Judge Southwick, a George W. Bush appointee, wrote the opinion and was joined by a Biden appointee, Judge Ramirez. And in their opinion, they reasoned that, quote, a country's encouraging its residents and citizens to enter this country illegally is not the modern-day equivalent of sending an armed, organized force to occupy, to disrupt, or to otherwise harm the United States. There is no finding that this mass immigration was an armed, organized force or forces, end quote. Inject that into my veins. I cannot believe this needs to be said, but they obviously have a thesaurus, and they know.
So as Melissa said, this opinion was 2-1. The dissent was written by SCOTUS hopeful Andy Oldham, who wrote a very long, very pick-me dissent in which the words Article 2 and President actually appeared in bigger font than the rest of the words in the dissent, which, I'm joking, they did not, but that is actually how these guys see the Constitution. And it was, all in on deference to the president and executive authority. I will give credit where credit is due. The dissent did refer to our friend Steve Vladeck as, quote, an esteemed commentator. So I guess stopped clock right this time. But I will say I genuinely didn't understand what this dissent was saying about what remained for courts to do, given the kind of deference he thought the president's determination was owed. I'm just going to read 1 or 2 sentences that I just have looked at a bunch of times and I can't parse. Quote, I am not arguing that the president has conclusive interpretive power to proclaim that AEA invasions include denying that baseball is our national pastime or double parking at the grocery store. I am arguing only that consistent with 200 years of precedent, we must treat the president's extraordinarily fact-intensive application of law to fact as conclusive.
It also had this very confusing / confused discursive about how even though the Supreme Court has said due process applies in the context of AEA expulsions, Judge Oldham is like, well, but what if it doesn't? Having said that he did, deign to refer to our friend Steve Vladeck as an esteemed commentator, did want to acknowledge that he just took some utterly gratuitous potshots at an article by Professor Lee Kowarski and Teddy Rave at Texas. Their articles about how habeas cases can proceed as class actions, and the Oldham footnote refers to them as, quote, the most ardent professional proponents of habeas class actions who rely on, quote, an ancien regime to make an argument favored in the faculty lounge, end quote. It's just very tired and lame and misleading since he doesn't acknowledge the civil rules about when the rules may rather than must apply in habeas proceedings, but whatevs.
I mean, especially coming from the most ardent professional proponent of muscular executive power. Right. So there's that. Anyway, the Trump administration didn't just lose in the Fifth Circuit. It also lost in the Ninth Circuit, where the court affirmed a lower court injunction that blocked Secretary Krispy Noem's efforts to terminate temporary protected status for more than 600,000 Venezuelan migrants. But that doesn't mean that Secretary Noem's TPS withdrawal is blocked, because the Supreme Court had already stayed the district court's injunction invalidating the TPS withdrawal. It does mean that this issue and this case is likely to go up to the court's merits docket soon, since if the court doesn't grant cert and decide the case, the district court's injunction would eventually go into effect. And obviously, our good friends at SCOTUS would not let that happen.
So mostly bad news for the Trump administration since we last recorded. One exception is that the 11th Circuit stayed an injunction issued against the Florida fascism facility, also known as Alligator Alcatraz. That injunction had required the government to wind down the facility. This 2-to-1 Court of Appeals opinion out of the 11th Circuit stayed that injunction with 2 Trump judges in the majority. Let me just briefly quote from the dissent. Quote, given the applicable burden on litigants who move for a stay, the deferential abuse of discretion standard that governs review of a preliminary injunction, and the clearly erroneous standard that limits appellate review of factual findings, the stay motion filed by the state and federal defendant should be a relatively simple denial. The majority, however, essentially ignores the burden borne by the defendants, pays lip service to the abuse of discretion standard, and performs its own balancing of the equities. It really makes you wonder where judges, like the judges in the majority on this panel, picked up that they could just ignore factual findings, accord them no deference, and basically abandon the abuse of discretion standard. Where might they have learned that?
I learned it from watching you, Dad. I mean, SCOTUS.
SCOTUS as Dad.
Yeah.
For sure. Okay, in more legal hot potato / legal shell game news, the D.C. Circuit has sent yet more important matters to the Court of Federal Claims, concluding that litigants brought their claims in the wrong place. This is just like what SCOTUS, or at least some of SCOTUS, said in the splintered NIH case. So here, a 2-1 panel of the D.C. Circuit with 2 Trump appointees in the majority and the opinion authored by another next top justice contender, Naomi Rao. This 2-1 panel concluded that recipients of the EPA's $16 billion in grants to combat climate change couldn't challenge the cancellation of those grants in federal court, instead had to go to the Court of Federal Claims. So the Trump administration here is terminating, again, more than $16 billion in grants, killing many research projects that were already underway, wasting all the work that's already been done pursuant to those grants because planet Earth is too woke, literally.
It's actually just about efficiency. That's efficiency. Scrapping existing research is about efficiency.
Billions of actual work done, materials in the ground, but nope. And that's what the D.C. Circuit blessed, unless and until there is successful litigation in the Court of Federal Claims, which historically proceeds at a quite slow pace. So in the meanwhile, they can just full steam ahead gutting health, the environment, and everything.
And a lot has been happening in the D.C. courts, so we're going to stay there for a bit. So remember that whole Humphrey's executor thing? Turns out the D.C. Circuit does know her. This is a vague callback to an earlier discussion I had with Melissa's colleague Noah Rosenblum. When the court decided Trump versus Wilcox, we said, Humphrey's executor, I don't even know her. Anyways, I thought that was funny. Humphrey's executor is the nearly century-old decision that says Congress can insulate the heads of multi-member commissions from being fired at will by the president. That is also the case the Supreme Court has ghosted on the shadow docket when it allowed the president to fire, in violation of federal laws, the heads of multi-member commissions, including the National Labor Relations Board, the Consumer Product Safety Commission, the MSPB, and those cases involved independent agencies that look a whole lot like the Federal Trade Commission, but not the FTC itself. Well, in this case, the D.C. Circuit declined to stay a lower court decision that had blocked the president from firing commissioners of the FTC, the very agency that was at issue in Humphrey's executor. In the vein of lower courts just trying to do their job, the court wrote, quote, Humphrey's executor controls this case. Recent developments on the Supreme Court's emergency docket do not permit this court to do the Supreme Court's job of reconsidering that precedent because we take the Supreme Court at its word, end quote. I like the fact that they're basically suggesting the Supreme Court's job is just to gut precedent now. That's how I read that line anyways. Judge Rao...
And unless and until you do it explicitly, you haven't done it.
Right, exactly. Judge Rao dissented, SCOTUS hopeful, because of course she did. And the Trump administration has already asked the Supreme Court to stay this ruling on the shadow docket because of course they would.
In other rulings against the administration, although this one is a little more complicated, there have been more developments in the foreign aid case before Judge Ali. Remember, this is the case where the district court concluded that the government illegally canceled and paused foreign aid. These developments are complicated and they're intricate. We think it's important to talk about them both because they are incredibly revealing about the government's conduct and motives and the Supreme Court's conduct and motives. So bear with us as we unpack all of this.
Okay, so since we last recorded, a 2-to-1 panel of the D.C. Circuit with 2 Republican appointees in the majority vacated Judge Ali's injunction, i.e. the D.C. Circuit undid the injunction that had invalidated the administration's cancellation of foreign aid. We'll explain the panel's reasoning in a second, but after that initial D.C. Circuit panel decision, the D.C. Circuit then amended its panel opinion and order in ways that seemed designed to avoid having the case be taken up en banc, i.e. going to the full D.C. Circuit. And indeed, the full D.C. Circuit denied the petition for en banc review after the opinion and order had been amended. So if you want to go deeper on this, Chris Geidner had a really great write-up of this at Law Dork. We're only able to summarize what happened because it's really everything everywhere all at once. But in brief, Judge Ali had concluded that the plaintiffs, foreign aid recipients, could challenge the president and U.S. Agency for International Development's cancellation of certain grants and contracts on the ground that that cancellation violated the Impoundment Control Act. That's a federal law that prohibits the president from declining to spend funds that Congress has appropriated. A 2-to-1 panel of the D.C. Circuit, that is that initial panel, concluded that the plaintiffs lacked what's called a cause of action, basically permission to bring suit, to raise their claims challenging those funding cancellations. The initial version of the opinion had suggested there was basically no legal claim the plaintiffs could raise, so it said any review of these grant cancellations was precluded under the Administrative Procedure Act, but the revised opinion says only that the plaintiffs lack a cause of action to enforce the Impoundment Control Act. That leaves open the possibility that the plaintiffs could challenge the funding cancellations on the ground that they violate other federal laws, including the appropriations bill that had appropriated the money to USAID.
Okay, so at the same time that this is going on, that is that the administration is challenging the preliminary injunction in the D.C. Circuit, they also asked the Supreme Court to stay the preliminary injunction. And they did so in part because had the D.C. Circuit granted en banc review, that would have vacated the D.C. Circuit panel opinion that had vacated the district court opinion. So the district court opinion would go back into effect. Government would have been again subject to the preliminary injunction requiring them to pay out these funds.
Confused yet? Good. Okay. The government's behavior at this point is, to put it lightly, appalling, hideous, terrible. The government did not seek a stay of the preliminary injunction in the D.C. Circuit when it appealed that ruling. And then the government insisted that it needed a stay because of the timing of the D.C. Circuit's decision, which the government itself had requested. And they told the D.C. Circuit that they needed a ruling by August 15th. But then the government comes back and says, oh, actually, this timing doesn't really work for us, and puts us in this predicament where the preliminary injunction might remain in effect. So then the government demands a stay from the D.C. Circuit and the district court, and then they just run off to the Supreme Court. Fix it, Daddy.
I know. So what happened? The D.C. Circuit declined en banc review, which meant the government didn't need a stay in the Supreme Court since the D.C. Circuit panel opinion vacating the injunction stood. But, the case went back down to the district court to figure out if the plaintiffs could challenge the government's actions on other grounds. And Judge Ali acted with astonishing expediency and care and said they could. So he rejected the administration's insane pocket rescission theory, saying it is impossible to square with the statute and that freezing funds requires action from Congress, not like a special message from the president. He also issued this footnote that called attention to the government's conduct in trying to, get the case before the Supreme Court on an expedited basis where they could try to say the D.C. District Court, they're doing all this horrible stuff and making our life so hard. So, the footnote said the court expresses concern that defendants' litigation strategy in this case appears crafted with the specific goal of ensuring review at the highest level occurs in an emergency posture. To the extent defendants have time pressure and billions of dollars to obligate, that is not an emergency, but a circumstance of their own creation. Those are excerpts from the footnote, but if this is the sort of thing any other litigant besides the federal government had done, there would be a show cause order for sanctions, honestly.
It does make you wonder why the federal government thinks that it really needs to just go to the Supreme Court on an emergency basis to get what they want.
I wonder.
It's
almost
what that's
like
about.
they are manipulating and making up the facts.
All right, last update in the first portion of our news segment. Big losses in the lower courts. We haven't actually had a chance to discuss yet, although it happened over a week ago, the federal circuit's ruling invalidating many of Trump's tariffs. So let's just briefly describe that opinion here. In this case, 7 of the 11 participating judges voted to strike down the tariffs at issue. These were tariffs announced in 5 separate executive orders, with the court finding these EOs unlawful and exceeding the scope of the president's authority under the International Emergency Economic Powers Act, or IEPA. These executive orders were predicated on declared emergencies, a number of them, one involving the southern border, one involving the opioid crisis, also reference to trade imbalances as emergencies. All of these things the president claims represent a threat to the national security and economy of the United States. And pursuant to those announced emergencies, the president announced huge sweeping tariffs on goods from a number of nations. So in this opinion, this majority of the federal circuit found that IEPA just did not give the president the authority to issue tariffs like this, particularly given the major questions doctrine.
Oh, snap. 4 of the 7 judges made clear in a concurrence that they don't believe the president has any authority under IEPA to impose the tariffs. The court remanded the case back to the Court of International Trade, that is the lower court that the case arose from, to determine what the appropriate remedy ought to be here, making clear that its ruling would not go into effect until October 14th. And predictably, the administration has run to Daddy SCOTUS requesting expedited consideration and November oral arguments. The cert petition, as you likely would expect, is icon-level crap. I'll just read. Quote, "The stakes in this case could not be higher. The president and his cabinet officials have determined that the tariffs are promoting peace and unprecedented economic prosperity. These tariffs present a stark choice. With tariffs, we are a rich nation. Without tariffs, we are a poor nation." End quote. It then goes on to quote Solicitor General John Sauer's letter to the Federal Circuit, in which he declared that the United States, without the benefit of tariffs, are, quote, a dead country, end quote.
Remember, we read from that letter, and I was like, I cannot believe this is a Solicitor General, but at least, it's a letter to the Federal Circuit. He hasn't filed anything this crazy at the Supreme Court yet, but
Oh, no.
Just you
More
wait.
than happy
goalposts
to.
are moving
and
really
he'll literally
fast.
recycle the same thing. Like he's quoting a letter he wrote himself.
he was like, this is so good. I'm going to take it out for
know.
another spin.
I cite myself.
Yeah. I'm also so glad we have our resident thespian back to do these dramatic readings
best.
because it just does not hit the same
Yeah.
when it's not you, Melissa.
So true.
Thank you. I appreciate that.
Okay, so in this tariff ruling, Judge Toronto wrote a dissent for himself and 3 others, arguing that the federal statute says the president can regulate in the face of an emergency and that the statute's prerequisites are satisfied here. Steve Vladeck had a great write-up of this issue at 1 First Street, in which he suggested that, this case is going to be added to the docket as well as others. And this was already a very full term. And the addition of this, plus now likely Alien Enemies Act, the temporary protected status case, maybe a funding case, will be wild. And yeah, that is going to be a very Trumpy term.
Yes.
Let's be real. Following the news cycle right now can be literally like sitting in a heat wave in New York City on the subway while watching floods of water roll toward your subway car. Like I'm saying, terrible. But people like you tuning out is exactly what the Trump media machine is counting on. On Strict Scrutiny, where we talk about the Supreme Court and the legal culture that surrounds it, you can help us by keeping our show at the top of your algorithm and the algorithms of other people who might like the show. So subscribe to the Strict Scrutiny channel on YouTube. It means not only will you not miss an episode, it will help other people, other like-minded people, find our show and help us shape this algorithm in a better way. Thank you.
Strict Scrutiny is brought to you by Americans United for Separation of Church and State. You don't destroy 250 years of secular democracy without gutting precedent, shattering norms, and dropping a few billion. The same people and groups that backed Project 2025 are part of a larger shadow network that's relentlessly pushing to impose a Christian nationalist agenda on our laws and lives. Church-state separation is the bulwark blocking their agenda. And one of the last bastions of church-state separation is our public school system. So they're pushing vouchers everywhere. They're also arguing for religious public schools. Yep, you heard that right, religious public schools at the Supreme Court in a case we talked about on the podcast. If you're listening to us, you're seeing the writing on the wall. We must fight back. Join Americans United for Separation of Church and State and their growing movement, because church-state separation protects us all. Learn more and get involved at au.org/crooked. This episode is sponsored by BetterHelp. We're coming up on another Supreme Court term, which means I've got a lot of feelings to share in group chats, with my dog, with the vast expanse of void. All of those are great options, for their own reasons. My dog is very empathetic, but talking with a therapist offers the chance to brainstorm coping mechanisms. Therapists are clinically trained and licensed to help you process the shit around you so you can keep on keeping on and stay in the fight. I'm a big proponent of therapy. I use it in general and then add on some extra when there's a lot going on. As one of my favorite lawyers says, every lawyer needs at least 2 therapists. BetterHelp has been helping people find their therapist match for over 10 years, and they have a 4.9 rating out of 1.7 million client session reviews. Therapy has really helped me maintain perspective, let a lot of the shit talking roll off my back, and generally stay in the game. But getting those benefits means finding the right therapist, and BetterHelp does the initial matching work for you so you can focus on your therapy goals. A short questionnaire helps identify your needs and preferences, and their 10 plus years of experience and industry-leading match fulfillment rate means they typically get it right the first time. If you aren't happy with their match, you can switch to a different therapist at any time from their tailored recommendations. With over 300,000 therapists, BetterHelp is the world's largest online therapy platform, having served over 5 million people globally. BetterHelp also offers a lot of flexibility. It's fully online, and you can pause your subscription whenever you need to and switch therapists anytime at no extra cost. It's convenient too. You can join a session with a therapist at the click of a button, helping you fit therapy into your busy life. Plus, you can switch therapists whenever you want. As the largest online therapy provider in the world, BetterHelp can provide access to mental health professionals with a diverse variety of expertise. Find the one with BetterHelp. Our listeners get 10% off their first month at betterhelp.com/strict. That's betterhelp.com/strict.
All right. Now moving on to our next segment, in which we do a deep dive on all of the lower courts expressing frustration with SCOTUS. So, First up, in the District of Massachusetts, Judge Young issued a heartfelt, or maybe it was just tongue-in-cheek, apology to Justices Kavanaugh and Gorsuch for his inadvertent defiance of their fake and non-existent shadow docket opinions. I'm going to say it was tongue-in-cheek.
I really feel like it's 50-50. Could be tongue-in-cheek, could have been sincere. Wait, describe what he said.
Yeah.
Okay. So Judge Young, for context, is presiding over the case involving the NIH funding freezes. And Justice Gorsuch, joined by Justice Kavanaugh, really went after Judge Young on the shadow docket, accusing him of essentially disregarding SCOTUS precedent and suggesting that he was part of an epidemic of lower court defiance. So Justice Gorsuch wrote this, quote, "This is now the third time in a matter of weeks this court has had to intercede in a case squarely controlled by one of its precedents. All these interventions should have been unnecessary, but together they underscore a basic tenet of our judicial system. Whatever their own views, judges are duty-bound to respect the hierarchy of the federal court system created by the Constitution and Congress." Personally, I think he should have just cited South Park. You will respect my authority.
Well, also, I was just going to say, Neil Gorsuch is a messy bitch who loves the drama, right? Like, he is making up this conflict. He decided he needs a plot line, right, in this season of The Real Housewives, and whatever, dude.
And we will have the clapback from Judge Burroughs momentarily, which was pretty epic. But so Young, in his very difficult to read response, so the case is back now before him, the case that engendered this, kind of nasty.
This bench slap, if you will.
Whatever it was. It's back before Young. And last week at a pretrial conference, he said, quote, "It is incumbent upon me on the record here to apologize to Justices Neil Gorsuch and Brett Kavanaugh if they think that anything this court has done has been done in defiance of a precedential action of the Supreme Court of the United States." He went on to say, quote, "I stand corrected, and those justices and the entire court can be assured that this court will absolutely obey the precedential decisions of the Supreme Court, as I have done and tried to do throughout all my judicial service." Now, I made it sound a little snarky. I don't know what the tone was because I don't think we had audio. So, I mean, I do think the precedential decisions might have been a considered choice.
Well, and also, as I have done and tried to do throughout, right?
Per my last email,
Also,
bitches.
all my sources, I'm pretty sure Young has been on the bench way longer than Gorsuch and Kavanaugh. And so I think that probably wasn't, accidental either to quietly invoke his decades of judging, for reals.
Like back when judging was more like a law thing.
Yeah.
He's like, I'm not new to this. I'm true to this.
Not unrelated is Lawrence Hurley had an absolutely stunning piece in NBC that included federal judges talking on background to journalists, basically shit-talking the Supreme Court, airing their frustrations.
Like judges, one or two of them?
No, 10 of them. So a dozen federal judges appointed by Democratic and Republican presidents, including Donald Trump himself.
It was basically Lawrence Hurley was Andy Cohen.
Yes.
And all these judges were it's time for the Real Housewives of One First Street. You're a bitch, you're a bitch.
Well, not even Andy Cohen. This is when the Real Housewives talk to the press behind each other's backs and are planting stories. That's more of this because 10 of the 12 judges said the Supreme Court, this is under the story, quote, should better explain those rulings, end quote, referring to the shadow docket. But the piece continues, quote, "They also have a new and concerning effect, validating the Trump administration's criticisms. A short rebuttal from the Supreme Court," they said, "makes it seem like they did shoddy work and are biased against Trump." Then there are a range of quotes talking about how what the Supreme Court has done is inexcusable and going so far as to say they don't have our backs and somebody is going to die. Right, talking about the escalating threats against judges and how the Supreme Court hasn't, done anything to temper that. And they accuse the court of, assisting the administration in undermining the lower courts with, some judges talking about them being thrown under the bus. And, one judge made the helpful suggestion that the Supreme Court should say something like, quote, "Let's be clear, it's not some crazy opinion, and this judge is not a monster."
Seems reasonable. To be fair, this was a story in which Hurley reported having talked to a dozen or so judges appointed by a range of different presidents. So there are Democratic and Republican appointees, and there were some dissenters among the group. So one Obama judge noted that the whole Trump derangement syndrome is actually a real issue, and as a result, judges are mad at what the president is doing or the manner that he's going about doing these things. And they are, according to this judge, sometimes forgetting to stay in their lane. Another judge also noted that the Supreme Court has an obligation to explain rulings in a way that the public can understand, and that when the court frequently rules for the administration in emergency cases without fully explaining why they are doing so, it sends a strong signal. And, the court has had strong left-leaning majorities in the past, but what's really different now is the role that these emergency cases are playing in the public discourse. So
I have some notes on these comments. What were those strong left-leaning majorities, plural?
Yeah, I mean, like, this must be a really old judge from the 1950s.
Right. I'd really like to hear more of this, but this story is stunning. It is so difficult to get judges to talk to reporters.
100%.
The fact that so many of them did so, and the fact that they were willing, again, to speak to them about concerns about the Supreme Court. I mean, that is a sign. We've talked about how Justice Jackson is sounding the alarm from inside the Supreme Court. These are other federal judges also trying to raise the alarm about what is happening with the Supreme Court.
So at the same time, the Chief Justice, and actually through his counselor, like his chief of staff type, Robert Dow, who's actually also, I think, still a sitting federal district judge in Illinois. He was, and then he became the counselor to the Chief Justice, but I do not think he's relinquished his seat. So I think he's technically still on the district bench.
Wait, how do we live in this world where people just have like 8 different federal jobs? Like Marco Rubio, this guy, this is bonkers to me, but whatever.
But I do think it might be relevant here. So he, in a speech at the Sixth Circuit Judicial Conference, was at pains to clarify that the Chief Justice's criticism of rising threats against judges in his year-end report had nothing to do with Trump, and that the Chief Justice really wanted to stay above the political fray. Now,
you're doing such a great job at that, John. Just
totally.
You're doing great, sweetie. You're doing great.
So Dow did apparently give a very sobering presentation about the rising threats to judges and, did not downplay the seriousness or severity, but went out of his way to make clear that when the chief tried to draw attention to and raise alarm about this, he was not talking about Trump. And in fact, he drafted all of it before the election. Okay.
Anywho, I think the upshot of all of this, the theme, the through line that you might take from this is that I think the district court judges have had it. Mm-hmm. And case in point, we got a very important ruling from District of Massachusetts Judge Allison Burroughs. In that ruling, she found that the administration had acted unlawfully when it rescinded Harvard University's funding. And the bottom line is, as she said, quote, "It is difficult to conclude anything other than that the administration used anti-Semitism as a smokescreen for a targeted, ideologically motivated assault on this country's premier universities, and did so in a way that runs afoul of federal law." She sided in the main with Harvard's claims that the administration's funding moves had violated the First Amendment, as well as Title VI of the Civil Rights Act, and were arbitrary and capricious under the Administrative Procedure Act.
Okay, so the clapback that we referenced a couple minutes ago came in just a hell of a footnote in which I think Judge Burroughs spoke
footnote 9, a lot of judges are using footnote 9.
Exactly.
That is, footnote 9
by
is the new
footnote 4.
Yeah.
Kate's referring to footnote 4 of Caroline Products, which is referred to as the most famous footnote in all of constitutional law. And Judge Burroughs has really given that a run for its money.
It's really quite an epic footnote in which he really does kind of seem to be speaking for the entire lower federal judiciary. And it's actually so good that I think we're going to read it in full, although it is long. So we will just break it up and take a listen. Footnote 9. The court is mindful of Justice Gorsuch's comments in his opinion in APHA and fully agrees that this court is not free to defy Supreme Court decisions and is, in fact, duty-bound to respect the hierarchy of the federal court system. Consistent with these obligations, this court, and likely all district courts, endeavors to follow the Supreme Court's rulings no matter how misguided it may think them to be. That's the quote of a Supreme Court opinion. Actually, it's not just her words. She continues, that said, the Supreme Court's recent emergency docket rulings regarding grant terminations have not been models of clarity and have left many issues unresolved. California, that's an earlier case, was a 4-paragraph per curiam decision issued in the context of a stay application. It cited Bowen as good law, stated that the Tucker Act gave the Court of Federal Claims jurisdiction over contract claims against the federal government, and then stated that the district court likely lacked jurisdiction to order the payment of money under the APA without purporting to explain how the case was distinguishable from Bowen or other related longstanding precedents.
The library is open because that was an epic read.
And she's not dead. She's just getting started.
Well, she's limbering up. There's more. This is a marathon, not a sprint. That's the first part of the footnote. It continues, quote, then, in APHA, 4 justices thought grant termination cases belong in full in the Court of Federal Claims, and 4 justices thought they belong in full in federal district court, and the decision was controlled by the vote of a single justice. The outcome, which no party had requested, was thus inconsistent with the views of 8 justices. And again, provided little explanation as to how Bowen, which the controlling concurrence again cited as good law, applied or was distinguishable. TLDR, what the fuck are you doing?
Yeah. And once again, she's not done. The footnote continues, quote, this court understands, of course, that the Supreme Court, like the district courts, is trying to resolve these issues quickly, often on an emergency basis, and that the issues are complex and evolving. Given this, however, the court respectfully submits that it is unhelpful and unnecessary to criticize district courts for defying the Supreme Court when they are working to find the right answer in a rapidly evolving doctrinal landscape where they must grapple with both existing precedent and interim guidance from the Supreme Court that appears to set that precedent aside without much explanation or consensus, end quote. Middle finger to all the haters.
Okay, we're finally done. Yeah. Oh. I was not familiar with her game. I now am.
Well,
This was like, I'm sorry, you must not know about me. I'm not the one and I am not the two.
Yeah. I just want to underscore, this in the NBC story, I love, right, like highlighting, what the district judges are doing, but like it is significant because the fact that they are willing to go out on these limbs is a sign of just how messed up and bonkers the Supreme Court is. I mean, Judge Burroughs is, the kind of very centrist, middle of the road judicial nominee that Democrats appointed, right? She is not some progressive warrior. She's like a U.S. attorney partner at a law firm, right? She's not some movement conservative lawyer, right? Of the kind that Republicans appoint to the bench. And again, the fact that they have pushed these judges so far is really an indication of just how out there they are behaving. There's so much of this Burroughs opinion we could read. I wanted to include this, which I felt like was very subtle shade as well. And
subtle?
I appreciated
Subtle?
it.
Subtle.
A little more subtle on the footnote, which wasn't subtle at all.
Right, exactly. So this excerpt was a callback to Justice Jackson's dissent in that National Institutes of Health, APHA case, when Justice Jackson had said this, which she was describing the Supreme Court's work, quote, is Calvin ball, but with a twist. Here is Judge Burroughs. Quote, it may well be that these differences would not distinguish these claims in the eyes of the Supreme Court, although that remains unclear under existing case law. But this is not Calvin ball, and there are rules, end quote. Basically, like, I'm doing the law thing, you guys aren't. It's not my job to predict what crazy shit you all are going to do and come up with a justification you can't even bother to come up with on your own. Yeah. Okay, so, and now, speaking of the galaxy brain geniuses on the Supreme Court, we will now talk about recent appearances by Brett Kavanaugh, who spoke at the Sixth Circuit Judicial Conference, as well as Justice Barrett. So Justice Kavanaugh announced at the Sixth Circuit Judicial Conference that he has figured out how to fix the shadow docket. His
I'm
solution,
listening.
call it the interim docket. Yeah.
How long do you think he had to workshop that until he got to it?
Honestly, probably the last 18 months.
I wonder if he had lists. Do you think he had a lot of lists of candidates that he's been
Yes.
marking up, and this is what he decided?
Bullet points.
Rose to
Yes.
the
Bullet
top. Yeah.
points.
Definitely. I mean, while we're at it, like, why not call it the we're perfect, we're beautiful, we're Linda Evangelista docket? Like, then there would definitely be nothing to criticize. Like, I have my own suggestions, right? Like shadow docket shit show or SCOTUS shit posts.
So his point is just sort of like, we're just riffing here. Like, call it the interim. Like, all of this could change. Nothing is permanent. It's just kind of the purgatory.
Well, he
docket.
basically goes
He
on
says
to
that.
say
Yeah.
that.
So listen, it gets worse, actually. So he's not only saying, like, if we label it something different, maybe people will be nicer to us. He kind of, like, gives the game away. So this is, like, the latest installment of the kind of Brett Kavanaugh can't help telling on himself, like, series, because his remarks included the following admission. He says, the shadow docket, nay, the interim docket, orders are cryptic because 5 of them can't, quote, reach a consensus or a compromise on a particular issue that might be difficult. So he says that, like with his mouth, he says that.
Well, and it's just like, how are lower courts supposed to figure out your secret reasons, right? And among all of your different secret reasons, figure out which ones are controlling. Because if there is no majority, like you have to pick the narrowest one, and you're not even told what any of their reasons are.
But if you guess wrong, you'll be screamed at by Gorsuch and Kavanaugh.
This had big, like, oh my God, he admitted energy, like the meme. If you don't know it, just Google that image, and that's Brett Kavanaugh.
Yeah.
So if Justice Kavanaugh is accepting other suggestions for what we might call the shadow docket, I'm going to offer respectfully for his consideration the following. How about the Dionne Warwick Psychic Friends docket, where you basically just divine what they mean by calling the psychic friends
I like
network
Dionne Warwick too much, so I would go with Mistress Cleo or something like that.
I think that works. I mean, it's basically what he's saying. Like,
yes.
It could all change at any point. Just you got to follow the vibes.
Right.
You got to be in tune with the vibes.
Yeah, you just got to be vibing out with them. Just do the vibe check, right? And that's
don't harsh the mellow. Stop asking big questions.
Right. And I just want to say part of what makes, the Gorsuch-Kavanaugh tirade against district courts, now laundered through Kavanaugh's meaningless civility feints, so appalling is that a mere 4 years ago, one Samuel Alito was lecturing people about how shadow docket actions and orders aren't precedential.
So we don't have actual audio of those remarks from his speech at Notre Dame because the speech is not on the internet, but happily, because of still free-ish press, right? Write-ups of it are still available. Kavanaugh is like a perfect encapsulation of civility means I can say anything I want about you and you have to take it on the chin and smile and tell me what a nice guy I am.
Also just returning to his struggles, like you can't count to 5. I vaguely recall Samuel Alito telling us that the entire disciplining force of appellate courts was working with and finding agreement with your colleagues. Like that was part of his rant against district courts in the birthright citizenship case. And yet Kavanaugh says, quote, consistency is a lot easier when it's one person than when it's 9, end quote.
Well, he did say, and I think this was true, he's like, we can do better. And I was like, that's right, you could.
Accurate.gif. Want to see some returns on that, but
I mean,
acknowledgement is an important early
part.
Step. So I guess we do have to give him a tiny grain of credit. Okay, just a couple more things to cover. Exciting news. Justice Barrett has begun her press tour for her forthcoming book, which clearly seems designed to cause Leah to pull out every hair on her head. CNN had an early report. It sounds as though in this book, Barrett defends overruling Roe with some recycled talking points about letting the people decide. We really implore Justice Barrett to keep this in mind when she is asked to strike down the Voting Rights Act. She also invokes the tired trope that RBG criticized Roe, ergo it was fine for them to overrule it. Melissa and I think, take on both of those arguments in our Dobbs and Democracy article in the Harvard Law Review, but just suffice to say we don't find them convincing.
She also defends what I think might be described accurately as craptastic decision making. So here's a quote. Before I joined the court, I was sometimes frustrated by an opinion's cryptic language or its failure to resolve fairly obvious points. Now, I better appreciate that glossing over the issues is often deliberate. This is some real Brett Kavanaugh energy, ma'am. Like, we're doing it on purpose. We're being cryptic and opaque on purpose, and you'll enjoy it.
But you lower courts, you have to know what we mean. Yeah. And
in all of our opacity.
Yeah.
Correct.
She really seemed to be on the same page as Coach Kavanaugh because she also made an effort to defend the shadow docket. Quote, as long as litigants continue filing emergency applications, the court must continue deciding them, end quote. Like, look what you made us do. Also, nothing tells you have to grant them if you can't fucking agree on a rationale. Maybe they haven't shown they're entitled to extraordinary relief.
It seems so obvious, and yet they're not.
And yet it escapes them.
Yes.
Justice Barrett did take the time to savor some of the big wins. She wrote how, one time when other justices quickly joined a particularly tricky opinion of mine, her chamber celebrated with impromptu champs. Which opinion was she celebrating? We don't know.
I think it's Vidal versus Elster.
Could be.
That Trump too small case.
Yeah.
Yeah, just for those who don't
I love
remember the
saying
name.
that.
It is fun to say. I
to
was
say.
thinking about it. The timing doesn't work for it to be her majority opinion in casa, but like the villain energy would just be boundless if she is, she's popping the champagne cork to celebrate removing a key vehicle for vindicating core constitutional rights for babies, for literal babies. She had a weird Computer Fraud and Abuse Act majority early on. I
That's
forget
not
the name of that
champagne
case.
What about
worthy. That's
Murphy
not
versus
champagne
Missouri?
Oh, but that was such a weird opinion.
I mean, I don't know. Just trying to come
Anyway,
up with.
there's
what
more
about
to
Howland
this,
versus
though.
Burkeen, Indian Child Welfare Act?
Oh, yeah, maybe. Okay,
Oh,
I guess
okay,
she can get a
maybe.
little give her. I grudgingly don't mind her having champagne because that dodged some really terrible bullets. So
Well, you assume that's the one she cracked open the
Right.
bottle for.
yeah, if she did, yeah. So
I'm going with Vidal versus Elster.
okay, toasting the inability to mock Trump's small hands. Yeah, that somehow checks
Yeah,
out.
no,
maybe.
this checks.
Yeah. That's what I'm going with. Anyway.
All right.
All right. Justice Barrett, it should be noted, decided to launch this particular book by giving an exclusive interview to noted journalist Bari Weiss. And subscribers to Weiss's Free Press had early access to it in a big event. So there are some highlights. We are not early access subscribers, but we did manage to get a readout on this interview. So here are some highlights. First up, if you were worried, rest easy, folks. Justice Barrett assures us that we are not in a constitutional crisis. She says, quote, I think the Constitution is alive and well. I think the country remains committed to the rule of law. I think we have functioning courts. Okay, girl. Like, okay.
Functioning lower courts. I mean,
But we have to talk about the lightning round, right? So at this lightning round, Weiss asked Barrett to describe each of her colleagues with one word. Should I, Melissa? Do you want
Let's
to do the
go through
dramatic
the
reading?
answers.
I feel like.
Okay.
I feel like.
All right,
need
you
to.
be Bari Weiss, and
Okay,
I'll be.
I'll feed you. I'll
God.
feed you. I'll feed you the justices. Okay. Roberts.
Chief.
Thomas.
Laugh.
Oh my God, I want us to do one. Sorry. Let's stay on track. But at some point, we need to do our own one-word descriptions of them. But okay, back to Barrett's. Alito.
Grandfather.
My eyes rolling so far back in my head. Sotomayor.
Lively.
Kagan.
Analytical.
if you're not watching this on video, you are missing an Oscar-worthy performance by
True.
one Melissa
Yes,
Murray.
it's true. Gorsuch.
Out west.
You got
oh, wait,
that's two words.
My bad.
All right. Kavanaugh.
Sports.
Jackson.
Actor. Broadway.
And scene.
Okay, Leah, go. And scene.
Where to even start with this? I mean, I took her comment about Alito to basically be like retire bitch. You know, the grandfather reference. It's obvious, right?
That and the Epstein's files is really the bipartisan consensus that we've all been waiting for.
Yeah, you know, the obvious, I don't know, disdain, like lack of respect, right? She showed her junior most colleague.
To be fair, I may have laced that with more disdain. Like, I
don't
didn't
know.
It was
We don't know that-
reported.
yeah,
It was
yeah.
reported as having a long pause,
Boss. Yeah.
right? And comparing that with what she said, right, about the other justices, I don't think it is unreasonable to infer from that, right, like a lack of respect for her colleague, right, who is doing a better job than anyone, right, at exposing and calling out the Supreme Court's bullshit.
I will just say, you know, so she, for listeners who don't remember this, she did a very brief cameo in the And Juliet production on Broadway. And I presume
She being Justice Jackson, not Bari Weiss.
No, nor Amy Coney Barrett. No, this was Justice Jackson.
They could never.
No. And Scalia and Ginsburg used to do
did that
cameos
too.
at the opera all the time. Like, not even cameos, like actually played little roles. I mean, cameos, I guess. But like, this is the thing they did. They got dressed up, they got on stage, they did a little opera. It's not that big a deal. It made me wonder whether in like the right-wing media ecosystem that Barrett, I think, inhabits, they were like, it was so improper. She like went to Broadway and she shouldn't have done that as a Supreme Court justice. And Juliet is like a kind of reimagining of Romeo and Juliet. There's like a young woman of color who plays Juliet. Juliet's like this empowered character who like doesn't offer self in, lovelorn sort of crisis. And there's like a non-binary character, and like it's a play that I can imagine like the right-wing ecosystem being like mad at. And I didn't know they were. But there was just so much in that, like, that's the thing that sprang to mind in, like, these 3 years of, like, fierce dissents and invocation of, like, Reconstruction thinking and history into constitutional jurisprudence. Like, she's like, I thought about this cameo in, like, this jukebox musical on Broadway. It was just, like, just so wildly, like, belittling,
One more quick thing. I feel like we often celebrate, obviously, on this podcast, and people elsewhere do as well, like Justice Jackson being willing to talk about what the Supreme Court is doing. But I think part of what this Barrett thing reveals is, like, there are costs, right, for people, right, who are putting themselves out there to draw attention to what is happening. And I don't think like the Republican justices and the Republican kind of ecosystem will forget that Justice Jackson has done this stuff, right, a few years down the road, even as or if like people who support her do. And yeah, I feel real like sympathy and empathy for her, like having heard this as well.
I think the way she can deal with this is to basically do what Justice Ginsburg did and invite one of her conservative colleagues to join her in her next Broadway cameo. And my suggestion would be for Justice Gorsuch, because he's
clearly
giving such frustrated theater kid vibes.
Totally.
Like, he wants to do it. So just like bring him along. Let him be Romeo. Like, little sing, little dance. It'll be fine. And then they can't
skip
then
that
she's
performance.
insulated.
But yeah,
she's
that's
insulated.
good. Good advice. Somebody get KBJ this advice. Stat. So that's all for this news segment. We will be back shortly with our interview with Justin Driver about his new book, The Fall of Affirmative Action. But first,
you've probably heard us mention Crooked Con over the last few weeks, but if you haven't, Crooked Con is your chance to join some of the smartest organizers and least annoying politicians in America to strategize, debate, and commiserate about where the pro-democratic movement goes from here. Hopefully up. We've been lightly hinting that we'll be there, but today we're excited to share. Strict Scrutiny will be closing out the event with a live show at the Wharf. To come see us, get your Crooked Con tickets at crookedcon.com. The ticket will give you access to the full day of conversations, panels, and workshops. Get your tickets before they sell out, and they will sell out at crookedcon.com. Strict Scrutiny is brought to you by ZBiotics. It's about to be a new Supreme Court season, which means it's as good a time as any to tell you about this game-changing product I use before a night out with drinks. It's called pre-alcohol. There's a surefire way to wake up feeling fresh after drinks. It's with pre-alcohol. ZBiotics Pre-Alcohol Probiotic Drink is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's a buildup of this byproduct, not dehydration, that's to blame for rough days after drinking. Pre-alcohol produces an enzyme to break this byproduct down. Just remember to make pre-alcohol your first drink of the night. Drink responsibly and you'll feel your best tomorrow. Every time I have pre-alcohol before drinks, I notice a difference the next day. Even after a night out, I can confidently plan on getting up bright and early the next day to canoodle my very lovely golden doodle. So that allows me to handle whatever fresh hell that tomorrow will bring without worry. More seriously, it helps me rise and shine so I can leave behind whatever the Supreme Court did yesterday and face whatever it might do tomorrow without rough mornings the next day. Fall is right around the corner, so that means it's time to raise a glass to your favorite team. Whether you are tailgating, enjoying a college game day, or watching Sunday's action on that fancy new TV, don't forget ZBiotics Pre-Alcohol Probiotic Drink. Drink a pre-alcohol before drinking and enjoy great days after celebrating all season long. Go to zbiotics.com/strict to learn more and get 15% off your first order when you use Strict at checkout. ZBiotics is backed with 100% money-back guarantee, so if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember to head to zbiotics.com/strict and use the code STRICT at checkout for 15% off. Strict Scrutiny is brought to you by Babbel. Got any fun trips coming up? One thing you probably haven't put on your packing list is learning the language. But with Babbel, you can start talking in just a few weeks. Start speaking a new language with confidence thanks to Babbel's conversation-based technique that quickly teaches you useful words and phrases about the things you actually talk about in the real world. There's over a dozen languages available to learn at your own pace, so you can achieve your goals with materials tailored to your individual proficiency level, interests, and time availability. You've heard us on Strict Scrutiny flexing our French and Italian muscles. I'm not yet quite sure what language I might try to learn next with Babbel. We are still planning next summer's vacation after all, but given the state of things, I might as well get a head start on some Russian. Handcrafted by over 200 language experts, Babbel's lessons are voiced by real native speakers and built with science-backed cognitive tools like spaced repetition and interactive features to fit any learning style. Babbel's tips and tools for learning a new language are approachable and accessible. It's like having a private tutor in your pocket. What I enjoy about Babbel is the speech recognition function, which helps to make sure I'm getting the pronunciation just right. Babbel also offers culture bites that deliver content and insider knowledge about the language, and you know your girl loves being up on the culture, pop or otherwise. With over 16 million subscriptions sold, Babbel's 14 award-winning language courses are backed by a 20-day money-back guarantee. Studies from Yale, Michigan State, and other leading universities continue to prove Babbel works. One study found that using Babbel for 15 hours is equivalent to a full semester at college. So get talking with Babbel. I want you to learn another language, so I'm teaming up with Babbel to gift you 55% off subscriptions, but only for our listeners at babbel.com/strict. Get up to 55% off at babbel.com/strict, spelled BABBEL.com/strict. Babbel.com/strict. Rules and restrictions may apply.
Hello, and welcome back to Strict Scrutiny, your podcast about the Supreme Court and the legal culture that surrounds it. We're your hosts. I'm Melissa Murray.
I'm Kate Shaw.
And I'm Leah Littman. And we are delighted to be joined today by Justin Driver, the Robert R. Slaughter Professor of Law at Yale Law School. We're huge fans of Justin's first book, The Schoolhouse Gate, and we're excited to talk to him about his important new book, The Fall of Affirmative Action: Race, the Supreme Court, and the Future of Higher Education. It pulls off one of the most difficult combinations in being both accessible and nuanced. Justin, welcome to Strict Scrutiny.
Thanks so much. I'm really glad to be with you all.
Okay, Justin, let's dive right into this triple sow cow, the perfect combination of accessibility and nuance. The book traces how the Supreme Court's June 2023 ruling in Students for Fair Admissions versus Harvard and the University of North Carolina dismantled 4 decades worth of precedent that had credited the limited use of race in higher education admissions. You describe SFFA as, quote, the most significant judicial opinion involving race in education since Brown versus Board of Education invalidated segregation 7 decades earlier. But you also observe that, quote, despite its significance, SFFA remains profoundly misunderstood. Can agree. Let's start with that. At its core, what did the court say when it decided SFFA, and how has the decision been misunderstood, mischaracterized, or manipulated in today's landscape?
Yeah, so the SFFA decision eliminating affirmative action was cataclysmic, deeply misguided in my estimation. It also did not sweep nearly as far as the Trump administration is attempting to suggest that it swept. That is to say, Chief Justice Roberts' opinion says that what's forbidden for universities to do these days is to consider race qua race. Those are the 3 most important words in the opinion. Race for the sake of race. Universities have interpreted this to prevent them from accessing racial boxes when they are considering applications, and that would be race qua race. There are other things that might fall into that category. What remains permissible for universities to do, though, is to make decisions with an eye toward increasing racial diversity. That is not prohibited, even though the Trump administration sent out a letter on February 14th of all days, a bloody Valentine's Day.
Happy Valentine's Day.
Saying, if a university decides to say, get rid of standardized test scores with an eye toward boosting racial diversity, that's prohibited. That claim is belied by the SFFA versus Harvard opinion. I think it's so important, by the way, to begin where you began, because it has led to a profound plummeting of black enrollment at our nation's finest universities.
Okay, so we definitely do want to come back later in the conversation to these kind of on-the-ground consequences of SFFA. But maybe to take a step back first, as I think kind of the opening characterization noted, the book is like both very practical and also theoretical, conceptual. So maybe let's kind of start with what you are arguing about the opinion's understanding of equal protection and how it both either breaks from or draws on earlier strains in the court's equal protection jurisprudence, right? Because just, for our listeners, right, what the court says is the equal protection clause forbids universities to do something it characterizes as using race qua race. So basically, I guess maybe I'll ask you to talk a little bit about your earlier article, The Strange Career of Anti-Subordination, which you use in the book to kind of highlight how equal protection doctrine and higher ed admissions policies have long reflected this deep tension between two competing interpretations of equality, right? So on the one hand, anti-classification, that is like the Equal Protection Clause forbids government to ever classify using race. And on the other, anti-subordination, something like the idea that what the Equal Protection Clause outlaws is government, furthering racial domination, subordination, hierarchy, but it doesn't forbid all action by government that uses race. So can you say more about those labels and categories and sort of how they operate in your view in the SFFA opinion?
Sure. To begin where you began, SFFA does mark a sea change. The Supreme Court of the United States had repeatedly considered affirmative action and its constitutionality and repeatedly upheld it, often with ambivalence, in Bakke itself, in Grutter in 2003, and in the pair of Fisher cases. Nevertheless, the Supreme Court had repeatedly said that it was permissible for universities to consider race qua race. The traditional divide in the Equal Protection Clause is exactly as you say, between anti-classification on the one hand and anti-subordination on the other. And the SFFA opinion is notable because Justice Thomas uses the term anti-subordination, the first time that that's ever appeared in the U.S. reports.
A little bit of Princess Bride. I'm not sure you know the meaning of that word, but, anyways.
Or maybe
Footnote,
he does. Or maybe he
Right.
does.
It's a fascinating move that he makes. Justice Thomas says, I am in effect an anti-classificationist, not an anti-subordinationist, but he routinely speaks in the register of anti-subordination. Mm-hmm. One of his defining moves, and we should understand him as a constitutional theorist, I believe, one of his defining moves is to say that the problem with affirmative action is that it does subordinate black people, that it suggests that black people left to their own devices are not capable of achieving. This is predicated, he says, on a notion of black inferiority. That is classic anti-subordination rhetoric. And so what I was trying to do in The Strange Career of Anti-Subordination in this book, The Fall of Affirmative Action, is to say that the story is more complicated than the one that we learned in law school, that liberals believe in anti-subordination and therefore affirmative action is A-OK, and conservatives believe in anti-classification, and therefore affirmative action must fall. But with respect to liberals, many liberal theorists have said that affirmative action does subordinate. That is to say, Derek Bell, the founder of critical race theory, says that affirmative action can be understood to envelop racial minorities in a cloud of suspected incompetence, he says. Randy Kennedy, Stephen Carter, and many other people have spoken in this register. So in that part of the book, I am attempting to engage my colleagues here at Yale Law School and throughout the academy who say, well, anti-subordination means affirmative action is A-OK. And I do try to, of course, weave in the litigants at issue in SFFA thinking about Asian Americans and subordination and how it plays out with respect to that group.
So can I ask you a follow-up there? Because, as you note, critics from both the left and the right of affirmative action have drawn from this anti-subordination theory to raise challenges to affirmative action. And of course, when you are talking about the badge of inferiority, right, that they allege, is stamped on minority applicants as a result of affirmative action, it calls to mind, this kind of infamous part of constitutional law in Plessy versus Ferguson, where the Supreme Court denied that separate but equal segregation resulted in a badge of inferiority on Black individuals. And I just wondered, in thinking about like these two claims about what produces badges of inferiority and how, when I think about ways in which, or possible ways in which, affirmative action might lead to a badge of inferiority, it seems to, in my mind, be drawn from a premise that almost assumes that Black and brown applicants don't belong and are less qualified, whereas, right, like it's not necessarily the result of the policy itself. It's like the combination of the policy and social facts, namely
the Stephen Miller response is like the perfect tell on that. So, after SFFA is decided, Stephen Miller's America First Legal Foundation sends out these letters to all of the law schools saying that there will be legal action if they're not compliant. But the question is, what would constitute compliance? What would be the evidence of compliance? And it's very clear.
And it's enrolling not as many Black and brown students.
Right. And that's not about that's not affirmative action. That's racial hierarchy. I think you could look at it at places where affirmative action had been eliminated even before SFFA. So I taught for years at the University of California, Berkeley, where affirmative action had been eliminated through a voter initiative in the 1990s. And, I still had students, Black students, who said, I think my white colleagues think I don't belong here. And I'm like, well, why would that be? Like, we don't have affirmative action. Well, I think it's because of the tenacity of racial superiority.
I think that's exactly right. Edward Bloom, the founder of SFFA, has gone around and said, in effect, we should be happy about Black students at MIT falling from 15% of the class to 5% of the class, because that 5% of Black students, they will know they made it in through the front door and they should have their heads held high. I think Melissa's exactly right. The experience of California is instructive here when students at UC Berkeley who were admitted decades after California got rid of affirmative action say that they are treated as lesser than by their classmates. They're not invited to join study groups. Indeed, they're not even believed to be students at UC Berkeley. There's a phenomenon people refer to as, sprawling while Black, being on Sproul Plaza.
Sproul
Plaza, pardon me. Thank you so much. So they are, walking around the plaza and they're not being handed out the leaflets because people believe that they're not students at all there. If you're being Black, it means you're not a student. And I think that you all are exactly right. The Trump administration here is being motivated by an idea that there are too many Black students on elite college campuses. That is the driving impulse. They are now trying to sort of seize university data, and they believe that there are just too many Black students on these elite college campuses.
Can I just note how insane the double standard is there? Because they are saying, right, efforts to increase racial diversity, right, are improperly motivated by race, and yet their efforts, right, to reduce the presence of minorities on campus, that's somehow a permissible motive. It's just, anyways, sorry.
No, it's a really important point. I've been talking with a wonderful student of mine here who has been pushing me on this issue. For a long time, conservatives think of, a horrible thing in the area of race is racial balancing. This is the boogeyman. We can't have racial balancing. That's a disaster. We can understand the Trump administration as engaged in a type of new racial balancing, right? To say that if the numbers sort of don't fall, then there is evidence of malfeasance somehow. So it's a very distressing time.
So the book is focusing principally on the Supreme Court's shifting visions of affirmative action and permissible uses of race in the context of affirmative action. But it is worth remembering that affirmative action actually begins in the executive branch through a series of executive orders launched by the Kennedy administration that was focused on integrating the ranks of federal contractors. And when those EOs were launched, they were explicitly remedial and reparative, which is to say they were meant to compensate for a very long history in which racial minorities had been excluded from the ranks of federal contractors. And at least initially, and at least until the Supreme Court intervened in Bakke, remedial or reparative interests were a big part of the underlying ethos of affirmative action programs and permissible. Bakke intervenes, and suddenly diversity becomes the cri de coeur for affirmative action programs. And I guess I'd like for you to sort of tease out what is gained or lost in the jurisprudence and on the ground when diversity becomes the watchword for affirmative action and the ethos that underwrites affirmative action.
Yes. So Justice Powell's opinion, the controlling opinion in 1978, says expressly that racial remediation is not meant to be the justification for affirmative action, that is impermissible. Instead, elevating the Harvard College model that said that, a farm boy from Idaho brings something to Harvard College that a Bostonian cannot, so too with a black student in comparison to a white student. The belief in diversity, although it may have started as an effort to offer a palatable solution, one that could sort of gain credence and acceptance, did become quite ardently believed on universities. I think that they pledge allegiance to diversity in intense ways. So, I wrote a study a long time ago now with some empirically minded scholars trying to revive the diversity rationale. I know that many people dislike it, but we examined the adoption of diversity policies on law reviews. This is at a time when law reviews were being sued because of their racial composition. And we looked at the effect of citations before and after the adoption of diversity policies to see what would happen. And we found that the adoption of diversity policies actually increased citations by 25%, a statistically significant figure. So one of the difficulties in SFFA is Chief Justice Roberts says, well, how do we really know how to measure diversity? This is impossible to measure, ignoring our article in the Columbia Law Review right before his eyes. So I think that this idea that diversity is just impossible to measure, there's no metric, Justice Alito says, I think that's mistaken.
I agree with you. Like the whole idea that you cannot measure diversity, that seems to be wrong-headed. I actually was thinking about some of the arguments that people of color have lodged against diversity that, why don't we think about this as remediation or a reparative interest? Like we were shut out of institutions like the University of North Carolina for many, many years. And this is an opportunity to correct that. And the downside of diversity is that it gives credence to the idea that Black people or people of color are there only to ensure that white people have optimal educational outputs or outcomes. And I think that's concerning. I mean, I've talked about this with my own constitutional law class as a parent. Like, that's not why my kids are in school. So white kids get a good education. I'm there for them to get a good education. And so, is there something lost at a granular level when we refuse to acknowledge or grapple with a history where there has been profound exclusion and maybe there is an interest in remediation or repair?
That point is quite well taken, the notion that Black students are there to educate others or as sort of window dressing. That seems like quite a powerful objection. I will say that one of the sort of ironies of the SFFA opinion is that it may open the door to revisiting racial remediation because of originalism. What does the conservative originalist do with respect to the Freedmen's Bureau? After all, that would seem to be rather strong evidence, contemporaneous evidence, that efforts to aid Black people pass constitutional muster under the 14th Amendment's Equal Protection
Well, Justin, you
Clause.
just ignore that part. That's the history and tradition that you can just put aside. It doesn't
No. They don't ignore it. Actually, Justice Thomas says in his concurring opinion, the Freedmen's Bureau, that wasn't about race.
Yeah.
Parenthetically, every significant historian thinks that's like crazy, that freed persons was synonymous with Black people, but just take that for the moment. He says that wasn't about race. Instead, that was about the status of having been an enslaved person, and whereupon, Justice Kavanaugh, during oral argument, said, but that means that preferences for the descendants of enslaved persons also, that would not be a racial category. So one of the proposals that I make in the book is that universities should contemplate adopting preferences for the descendants of enslaved persons, which would go back to the in many people's minds, the strongest justification for affirmative action about historic injustice and the legacy with us today of that injustice. Many conservatives have suggested that this is constitutionally possible, including Michael McConnell, David Bernstein, and other people associated with the Vladeck conspiracy. They're invited to the cookout. They're invited to the Mayflower. They're when the Federalist Society holds its convention. And so I think that this is an exciting idea, and I hope that universities will take it seriously.
Just want to pause to remind you that during oral argument, Patrick Strawbridge, when fielding that question from Justice Kavanaugh, noted that slavery was too closely correlated with race for that to work. And we remember, ladies, we said, why would that be? Why would slavery be so closely correlated with race?
That point is very well taken. At the same time, if one takes seriously SFFA versus Harvard, and that what's forbidden is race qua race, that is not a racial category in modern America. That is to say that there would be black people who would fall into the category of descendants of enslaved persons, and also plenty of black people who would not fall into that category today. I, of course, am completely committed to the proposition that slavery and race are deeply intertwined in American history. You don't have to convince me on that front.
Good.
But there are lots of relatively recent immigrants to the country who would not be understood to be descended from enslaved persons.
So we are now in a new era when it comes to affirmative action, and we wanted to talk about some of the practical. We've already talked about how you have suggested that, people on the left who embrace the anti-subordination theory have failed to grapple with how, affirmative action might implicate their theory. And in your book, which is also expanded in your recent New York Times op-ed, you similarly observe that with respect to the other side, quote, conservatives have often excoriated affirmative action because they argue it makes racial minorities see themselves as victims, end quote. But the irony of SFFA decision is that, as you write, quote, Roberts' opinion promises to intensify victimizing narratives. How did Roberts' opinion create the conditions for this, or a potential trauma dumping fad? And what does that imply more broadly about SFFA's inability to achieve its intended ideals?
Yes, so conservatives have long had affirmative action in their crosshairs. It seems to me that they have done an inadequate job of contemplating the new regime that was going to replace the old regime. And so with respect to victimization, which Shelby Steele and many other conservative commentators have said affirmative action heightens victimization, I actually think that this decision, SFFA expressly says that it's permissible for applicants to write essays that sound in moves of racial discrimination, inspiration, or otherwise. And so this is a new world. Under the old regime, a black applicant like myself could check the black box and then write an essay about why I wanted to study, Proust or Plato or string theory or anything else. And under the new regime, because universities are prohibited from accessing the racial boxes, people are strongly incentivized to write essays about their brushes with racial discrimination, and that narrative is going to become deeply embedded in the students who are polishing their essays over time. This is not something just checking a box. It requires numerous revisions. And of course, it's going to trouble this conservative idea that the nation has witnessed enormous strides toward racial progress. This is something that's very important for Chief Justice Roberts and his conservative colleagues, as evidenced by the Shelby County decision. But here, students are going to be incentivized to say, this horrible thing happened to me, and this is evidence that the nation hasn't gone as far as people would like to believe. And so here I am trying to channel conservative argumentation and take their professed ideals seriously. And I would say that a similar phenomenon could be found with respect to their mismatch idea. I personally don't believe that mismatch is a significant thing, but they say that it is a big deal, and I believe that this decision could heighten the mismatch concern.
So the point you just made about this new landscape giving students more opportunities to really kind of flog their victimhood, a new sort of oppression Olympics in the essay section of the application process. This was the subject of your recent New York Times op-ed, and I think it was very compelling. I wonder what you would say about that theory in light of the recent directives from the administration that universities share their admissions data with the DOE going forward, because it would seem that that sharing mechanism or that requirement to share data would be a really strong deterrent to universities to admit only students with the right kinds of metrics. That is to say, really good GPA, really good test scores, and leave aside those students who may be on the bubble, but who write really compelling essays and, compelling for whatever reason. So do you still think, given this new landscape where schools are going to be obliged to share their data in very explicit ways with the administration, that the same concerns about the essay and the prospect of victimology are as acute?
Listen, if I were offering advice to a high school senior, I would encourage the student to write the essay that they believe is going to enhance their chances. And very importantly for me, I really want to make it clear that there's a lot of misunderstandings here. I write about in the essay that you all have been mentioning a student from a poor part of Atlanta, an African-American student, DeMar Goodman, who was under the misimpression that SFFA said you can't talk about race any longer, and that's exactly wrong. So it's not that I would say people shouldn't do it. I want them to be aware of the consequences of this new regime. And with respect to the sharing of the data, I was deeply troubled by Columbia and Brown University's agreement to hand over the data, which then the Trump administration said, we need all of this data. Not so much because of what the data will reveal. Admissions officers have, exactly as you say, Melissa, a tremendous amount of discretion over who to admit. They're not just taking the sort of highest scores and across the board. That's not what they're doing. They're trying to round out a class. But I was alarmed because of what it signals for the Trump administration. That is to say that they are trying to depress Black and Brown enrollment at these schools, even though Brown and Columbia had already suffered a 40% decline post-SFFA. So, I think that the nation has a lot of profound troubles right now. Too many Black students on elite college campuses is not among them.
Okay, so can we maybe stay on the where we go from here point? Because although the book is, as you have been in this conversation, sober about what you describe as the calamitous results of the opinion, it also is very self-consciously not defeatist, right, about what universities remain squarely able to do within the confines of SFFA. And so you've already talked about potentially offering a preference for individuals or descendants of enslaved persons. And you talk a little bit about some of the potentially practical difficulties of implementing, but you don't think that any of that is insurmountable. Can you talk a little bit more about other kinds of mechanisms that you do think remain squarely lawful after SFFA? And then maybe do you want to respond a little bit to kind of a skeptical listener who says, well, there's already challenges to other kinds of preferences that either schools or other kinds of institutions are trying to devise that are not on their face about race qua race, but the Stephen Millers of the world would nevertheless like to take down?
Sure. There are a lot of ideas in the book, but let me tell you about three, apart from the preference for the descendant of enslaved persons. A preference for people from low opportunity areas. I make the claim that universities could set aside, even have a quota of 10% of the class for people from low opportunity areas. There's a wonderful publicly available resource called the Opportunity Atlas by Raj Chetty and John Friedman, where they take census data and pay attention to numerous factors that are correlated with disadvantage, including teen pregnancy, incarceration rates, family income, these sorts of things. And preferences for students from those areas would be valuable. There's a wrinkle to that one, though. I think it would make sense to have 80% of the students from low opportunity areas come from urban areas and 20% from rural areas, because if you just say low opportunity, I don't believe that's going to have the intended effect. But that is not race qua race. Chief Justice Roberts says directly in the opinion, preferring somebody because they live in a city is different than race qua race. Okay, second, and I'll be quicker here, a preference for tribal members would also be available. Too often we speak only about Black and Brown students in this area. Native American enrollment plunged after the end of affirmative action out in California. And the Supreme Court of the United States has said preferences for tribal members is not a racial category. It's not the same thing as Native Americans generally, and so that's another option. The third option would be for these universities who have ivory towers that cast long shadows over black and brown neighborhoods to form partnerships with local schools that have a high black and brown enrollment. And that is just like the Texas 10% plan in many respects, which has not been understood to violate the Constitution of the United States.
So can we focus on something you alluded to just a minute ago, the impact of SFFA on the enrollment of minority students in elite colleges over the course of the last 2 years? It has raised concerns about potential ripple effects of the decision in business, in politics, in leadership. Basically, the argument is that this decision is going to have real consequences on the fabric of a pluralistic democracy, just because the numbers have become perilously low in just 2 years. For those who want to feel more optimistic or to support a more positive future for all of us, what can we do? Are there broader correctives that might be implemented that we all could participate in?
Yes. So I think that you're exactly right that we are looking at a lost generation of black students on elite college campuses. And Princeton, by the way, just reported its data, and this year's first-year class went from 9% black to 5% black. So I worry that there are many more shoes to drop over time. You know, the book is focused on universities, elite universities, because what happens in those courtyards plays a disproportionate role in shaping what happens throughout the country as a whole. So I really am trying to focus on what tools remain available to universities to enroll significant numbers of black and brown students. You know, sometimes when affirmative action comes up, people say, oh, it's just such a late intervention, you know, we need to get involved in the K through 12 environment. And, you know, maybe there is some force to that argument, but nothing's prohibiting people from getting involved in the K through 12 environment with the existence of affirmative action. And so the idea that now, in the aftermath of affirmative action, I haven't seen people racing headlong to redistribute funds or, you know, start up these sorts of programs. So it always struck me as a bit beside the point when people make these arguments. And I guess one of the other things that I do want people to appreciate about affirmative action is that it has made tremendous contributions to our nation. In 1960, Harvard, Yale, and Princeton had 15 black students total out of 3,000, 0.5%. You flash forward a decade later, it's right around 300 black students. And what happens there, exactly as you say, Melissa, is going to shape what happens in the business world, in the world of academia, in the world of the legal profession and beyond. And so, given the declining numbers, we're going to be dealing with this for the decades to come.
So, as part of our effort to end our episodes on a more positive note, Justin, we've been inviting our guests to share things they have read, watched, seen, or, you know, otherwise enjoyed in the last week. So would you mind sharing your recommendations with our listeners?
Sure. So I've had a couple of occasions to revisit some things over the last week. I'll tell you about two of them. One is a book by Rick Rubin titled The Creative Act, A Way of Being. This is the great music producer, Rick Rubin. I'm quite confident that he didn't write it to help my little life as a law professor.
Or did he?
He really does democratize creativity and not talk about I was in the recording studio with this particular person, but instead the mindset of those of us who are involved in trying to create. So it's made a tremendous positive difference in my life. I constantly think about the mindset of abundance versus the mindset of scarcity. We want the mindset of abundance. The other thing that I just reread the other day is a law review article written by Randall Kennedy of Harvard Law School, who was my professor back in the day, my dear friend today. He's written a lot of great law review articles. I'm going to recommend Martin Luther King's Constitution. It's a Yale Law Journal publication from 1989, not nearly as heavily cited as Racial Critiques of Legal Academia or his piece on McCleskey versus Kemp, but it is a model law review article in that he's engaged in thinking about the Constitution outside of the courts and taking seriously Martin Luther King, who lacks a legal degree, engaged in legal decision making. So I just reread that the other day, and I commend it to your listeners.
All right, those are terrific recommendations to end the conversation. That is all we have time for today. The book, once again, is The Fall of Affirmative Action, Race, the Supreme Court, and the Future of Higher Education. It has a very nice cover. The author is Justin Driver. Justin, thank you so much for joining us today.
Thank you. I really enjoyed the conversation.
And thanks to our incredible intern, Jordan Thomas, for his help in preparing for today's episode.
Thanks so much, Justin Driver, for that terrific conversation. And since Justin offered up some of his favorite things, I think it's only fair that we provide you with some of our favorite things from this week. So, Kate, why don't you go first?
Sure. So I will first recommend a new essay by Alexandra Petri, who is now at The Atlantic, who's got a great piece titled Apologies. You have reached the end of your free trial period of America. I'll just leave it there. Wonderful piece, hilarious and dark, as she so often is. And then two others we've already mentioned, I don't know, at least twice during this conversation, but our friend Steve Vladeck and his One First Street newsletter is always a must read. I thought his latest bonus installment about like holding on to law and refusing to give in to kind of nihilism and hopelessness was like very bracing and energizing. And I highly recommend it if you are feeling down about the prospect of law in this moment, as is a reasonable response to the lawlessness of so many players in the landscape. So great piece. And then finally, the insane piece of New York Times reporting that dropped either Thursday or Friday. I just read it today, Friday, about this SEAL Team 6 mission to plant a listening device in North Korea that went horribly wrong back in 2019. I mean, it is just an absolutely riveting read. And it's also terrifying to contemplate that all happened in 2019 when there were still people in the military leadership willing to stand up to President Trump compared to now after the installation of Hegseth and the purge of so many top military leaders. So I think everything is going to go great with future clandestine missions, but definitely read that piece.
Well, we'll read about the clandestine missions in Signal, so don't worry about it. Yeah, we'll find out.
So my recommendations are one piece I've already mentioned, Chris Geidner's Law Dork post explaining the machinations in the D.C. courts over the foreign aid funding case. Also wanted to highlight some additional posts by Steve Vladeck at One First. One is Playing the Justices for Fools. This, too, was about the D.C. foreign aid litigation. And then Kate appeared on Ezra Klein's podcast last week when we were off, and I thought that was just a fantastic episode.
Thank you. Oh, yeah, that worked out well. We dropped it. That episode dropped like the day that we were dark for the holiday. Yeah. So completely inadvertent. But yeah, that did work well. Sorry.
I think we're just going to start calling it the Strict Scrutiny Ezra Klein crossover and let him correct us. Okay. Anyway, he will correct us, I think. Anyway. So my favorite things this week are as follows. First of all, I loved Secretary Build-A-Bear, that is Secretary Robert F. Kennedy Jr., who was at a hearing before members of the Senate last Thursday. And all I can say is, listeners, pop your corn and settle in because it is a scene. Bernie Sanders ranting, Maria Cantwell, who I don't think is prone to hyperbole, calling RFK Jr. a charlatan on the record. Amazing. It was fantastic. It's basically like a Schadenfreude sound bath. So just let it wash over you. It's fantastic. And if you loved that, you will also love New York Magazine's Reeves Weidman's in-depth story about how almost all of the Kennedy family are actually really appalled with RFK Jr. and may want to excommunicate him. I'm here for all of this drama. Highly recommend it. In addition to those, I loved Hysteria's episode this week. They had an installment of their series, This Fucking Guy, and this time it was about Nancy Mace of South Carolina, and I learned so much. It was just absolutely fantastic. I'm also reading Sarah MacLean's These Summer Storms, which Leah recommended to me. Loved it, loving it right now. Also read the Gwyneth Paltrow biography. I know, the unauthorized. And I'm telling you, I love Gwyneth. I will not hear a word against Gwyneth, but I will read them. So, and there's a lot here. This is great.
So that's all for this week. But next week, we will be back with a very special segment with a very special first-time guest we are super excited about. So stay tuned for that.